Good evening, everyone. This is Abhivardhan from the Bharat Pacific, and this is an important event which we are having today. This is the book inauguration and release of the 2020 Handbook on AI and International Law. In this session, we have some eminent guests who will release the 2020 Handbook on AI and International Law. This is a very important publication which we have had published last year under the Indian Society of Artificial Intelligence and Law, and there were due to some delays we could not proceed. However, at this auspicious occasion, let me introduce our guests who are under the aegis we are proceeding. So we have our chief guest, Honorable Justice Jarmida. Uh, he Sir just retired recently in late 2021. He was a judge of Delhi High Court, and Sir has been present in various matters wherein his judgments on issues related to commercial law and arbitration have impacted the Indian legal system as well as advocated a lot of reformist considerations. It's a pleasure to have Justice Jarmida as the chief guest in this session. We also have Bogdan Grigorescu, who's a technology expert. We have uh, Akash Manwani, Manohar Samal, and Sanad Arora, who are the contributors to the 2020 handbook. We will also have Mr. Ish Jain, who is an international arbitrator, joining in some time. So, as we may proceed with the session, I'd like to request Honorable Jayamida sir to give his special remarks on the 2020 handbook. It was a pleasure to gift him, and I'd like to know what does he think about it.
Thank you, Abhivardhan. Good evening, ladies and gentlemen. It is a pleasure to be on this occasion to release a book written by Abhivardhan. I had a very short interaction with Abhivardhan few days ago when he met me and briefed me and also showed me his work. It is an extraordinary work done by him, and I must compliment him. You see, I was on bench for 14 years. I have also written 3 books, and one book is under preparation. And I must uh, uh, admit, writing a book is a very difficult thing. Even writing of a judgment is easier, but writing book is very difficult work. It can only be written with a great effort and great understanding of the subject. And Abhivardhan, who is a very young and bright, promising person, has written a book on a difficult subject. And I compliment him and congratulate him and look forward for his more works in future. It is a brilliant work, and it is a uh, food for thought for all the readers who go through this work. And with this, I release the book and look forward for more books coming in future and wish him great success in this book. Thank you very much, and I hereby release the book open. Thank you.
Thank you so much,
Congratulations
sir.
once again.
Thank you so much, sir. It was a pleasure to host you, and maybe in future also we may have such discussions and discourses where we could have your ages. Thank you so much, sir.
Thank you. Thank you.
So, as we move forward with the session, let us give an intro of the 2020 handbook. Let me also introduce my co host, Aditya Jacki. He is a public policy geek, especially on economic matters related to international relations. So, Aditya and I are going to host this discussion wherein we will talk about this handbook, why it mattered for ISAIL, and how does it impact AI and law research discourse for both the academia and the industry. Here's a video featured by ISAIL in which we explain in a very simple way the chapters of this handbook, and how does this handbook shape up? Here's the video. So this project itself was very impeccable. It took 2 years to uh, develop this handbook. It was not an easy effort, and trust me, for those who are technology law practitioners in India, I must say we tried to contribute some of the best analysis and case studies on various aspects of AI and law. So I think we would be waiting for Mr. Ish Jain to join in some time. Uh, so I think we have Mr. Ish Jain with us. Sir, welcome to the session. We are live. So we have had our special guest, Justice Midha, who had delivered his remarks, and due to certain reasons, he had to leave early. But I'd like to ask Aditya to take up the baton and discuss about the handbook and what are the trends related to the legal implications of AI with our guest. So, Aditya, over to you.
Hello, Advocate Isjan. It's nice to meet you and have you in this session. So the question I have to
Nice.
you is, how do you think this handbook is a valuable contribution to the AI and law discourse, especially for people who want to develop their careers in the field of alternative dispute resolution and technology law? If you may, like answer this question.
Well, a lot of lack of knowledge is there amongst a lot of practitioners about technology law and of how artificial intelligence affects. Just a minute. So a lot of technological what do we say know-how is not to the knowledge of practitioners, and because of this lack of knowledge, either the law is not correctly implemented or uh, it's misinterpreted. And when that happens, and in a stage where a dispute is going on, before arbitrations or before courts, it leads to improper outcome. It leads to a possibility of challenges. It leads to a possibility of overturn of the awards. It leads to a possibility of overturn of the final judgments which have come in, which not only waste time of the lawyers that are involved but also the parties that are involved, and it increases the cost for them because now it's another round of litigation, it's another round of appeal. It takes its time. So this book basically brings to light a lot of legal aspects. It keeps it very technologically simple, but it also tries to bring into those lawyers and practitioners the technical know-how that is necessary to interpret these terms, technological terms. So I think it should be a good addition to anybody's library where they have to constantly deal with these kind of matters, and they can refer to this book. They can refer to the interpretations and references which are made in this book, and it will be beneficial to them.
Just as a follow-up question, generally it is said that legal frameworks always catch up to the technological advancements, basically. Like technological advancements happen, then after a very long time, the legal framework catch up to it. By that time, like the world has already moved on. So, given that India is already going through its technological transformation, the government of India is trying to bring in new data protection law. Like a lot of work is happening in terms of legal paradigm. Do you think this book addresses that gap between that? I mean, do you think it addresses those questions, issues, and do you think India is still playing catch up, or like we are kind of on the course to understand how?
Well, I think we'll always play catch up, because that's how it's going to remain. And it's not just us, but I think except for the European Union, everybody's playing catch up. I think the only union which is not playing catch up is the European Union, and I think they're acting. I mean, some would criticize that they're acting too prematurely also. So you have the pros and cons of this different approach, but whether it's technology or whether it is any other kind of crime, the law will always play catch up, because the first course of development is always going to be the crime, and then you devise a method of qualifying it under a criminal code. So it's always going to be catch up. So whether India or any other country, the only differential point is, when did the crime start getting noticed in India? For example, cyber frauds were happening in the US in much more earlier days than India. So the law developed faster over there. In India, we detected it, we found out, we then codified it and then tried to implement it. Today, data protection is not considered as a big threat, except for a few corporates, which is hardly 1% of the kind of people that we have in India. But data protection in the US is affecting every single person, and they're concerned about it. Now, the difference is that we will have to wait to that social point where the individuals are affected by it. And when we reach that social point, the need for data protection increases, and then we have the data protection law. And now we've reached that stage where individuals are affected. After the news which we keep seeing about different data protection leaks, and frauds which are happening, or the identity thefts which are taking place. Now the people are becoming more and more aware, and they're more concerned with their data, they're more concerned with their online presence, and hence the data protection law is now getting formulated. So it's always going to be when the social IQ is raised. And the books in this regard play a key role of how you bring that awareness to the people. So this book basically brings forth the other issues which are there in technology law. uh, and once people are aware of that, you know uh, disputes, it brings to their mind that yes, we require laws for that protection, we require laws to regulate this industry, we require legal framework to deal with these kind of disputes. So the foundation for every social upbringing and social IQ level to be raised is the books. And there cannot be any book which is not helpful to bring that up. And this, I think, suffices to say that you know should be something which most practitioners should read, because they'll then become aware of these insights.
Thanks for the response. Yes, Abhivardhan.
Yes, I think we can bring other people also into the discourse. So I think we can then move on with Bogdan, and then we can discuss about the experience of making this book with Akash, Sanad, and Manohar.
The problem is also the other side, right? Engineers don't know about law, generally speaking. They just don't know how law works, how laws are made, how laws are thought of, the legal process, which is a very big part of what the lawmakers are doing, all the logistics behind it, the documents aspect, the human rights in court, and so back and so forth. So that's also an equivalently big problem in the age of planetary automation. because if you don't have a thorough understanding of the context in which purposeful solution is to be designed, built, put in action, maintained, and so on, then chances are it's just to go amiss. Um, so engineers and the technical community has to skill themselves up in law, not to be lawyers and experts, of course not, but just understand the basics, the basic principle of laws. Um, that means going back to Roman times, which you know they're the biggest contributors to law in the world, in the history of humankind. So Roman law uh, and the rest. But the elementary, the principles, to really understand them and how they work and essentially bring order to our society. And then develop solutions, technical solution with that in mind. Until that happens, I'm afraid we are not going to be on a good path here. So both legislators and people in the legal domain have to understand how tech works and the basic of technology. In the case of AI, they have to understand about machine learning, about AI in general, which is more of a philosophical concept, but nonetheless very real concept. It is not wishy-washy and some sci-fi things anymore. It's here. But also the basics of engineering, just the very basics about how signals work, what is a signal, because in the end of the day everything it's about signals. You press a button, signals are generated, but what is a signal? So things like that, just the very basics, and develop this little bit of this mindset to understand how engineers work. The same is true for engineers when it comes to laws and regulation. So they have to work together really. The legal domain is to be probably one of the biggest stakeholders of technology. But vice versa, technology is to become one of the biggest stakeholders of law. We already talk about, right, in the last 2 years, 3 years, about tech law, which is a new aspect of the legal system, tech law. So from my perspective as a technologist, we have to read and talk about law when we think about technical solutions. So we have to involve the relevant law professionals, not everyone, but just those that will likely have a standing into the developing of the technical solution going forward. That did not happen much before and does not happen much today, but is a necessity. Otherwise, we end up with, TAE type of chatbots that are easily hijacked. They don't abide by any legal principles, not universal principles. Shaky guardrails, no matter what OpenAI says, is being hijacked within couple of weeks from launch to the public. That so-called DAN GPT, which is do anything now. So that's currently on version 5 or 6 already on Reddit. So there you go. That's what happened when there's a legislative vacuum. So there has to be a level playing field. That's the point of regulation and laws, but just not heavy-handed, because otherwise we end up with a parallel economy that circumvents all that, and it is not going to amount to anything good. So not too heavy, balanced, but enforceable on the other hand. So not too heavy, legislation that makes sense, but for that both the engineers and the lawmakers have to understand each other really good.
So Bogdan, following up it on that, like where do you think technology lawyers and developers can actually contribute to make better AI products? Do you have any inputs as a technologist? Because like as you have said, engineers and the lawyers are from the opposite end of the spectrum, and both have completely diametrically opposite perspectives.
The in a big company will always have a legal team. That's a good starting point. Um, Involve the necessary people from the legal team and data governance in any new solution, technical solution. That will, it's supposed to cater for needs of people, of society, and so back and so forth. Involve them, not somewhere in the middle that, oh, we want to run this past you to see if we have a legal risk here. Are we doing anything illegal? That's not at all sufficient. Of course, it's a minimum and is very much needed, but is not sufficient. So, so ways of working have to change. On the other hand, the legal team has to involve regularly the relevant people from the engineering side in legal developments, important legal developments, not everything, important. Like, for example, continuous training on GDPR, let's say. Make it mandatory. Once a year, you have a refresher training of a couple of hours just about the most important aspects of the GDPR, and keep those us people in the tech updated on that, because yes, there's documentation everywhere. Would we ever remember and know what to read, what first and prioritize? No, we won't. It's just not possible. But with a refresher course, make it mandatory every year, couple of hours, maybe half a day maximum for everyone. I'm talking from the CEO down. Everybody has to have that refresher training so that we're up to scratch with the latest developments, and we can understand what it means for our work. So education and training, very important and critical. But on the other hand, people in the legal teams of companies should undertake certain basic introductory training to the relevant technologies. For example, I talked before about machine learning, natural language processing, things like that. Catered trainings that is catered for them, for that audience, not a generic training that is mostly either for, I don't know, maybe junior people in the engineering domain, and you see them on LinkedIn, Coursera, everywhere. Not those. Those are not good for them. They have to be attuned for the legal audience. Those materials have to be attuned for the legal audience. And they should undergo that training at the refresher every year as well, mandatory. In what makes sense, not in everything, in what makes sense. Again, half a day, 2 hours, a few hours every year, to make sure that actually they develop law that are for the current and the next stage of affairs, and not from the past. If you look at GDPR, everybody says, well, it's from 2018. No, it's not. It's from 2013. That's when it was start being devised. That's the mindset. That's the state of affairs we're talking about. 2013. What happened between 2013 and 2018? Well, groundbreaking things happened. GDPR didn't take them into account because it couldn't, because the mindset was 2013. So actually, GDPR went into life at end of May 2018, but companies had 9 months to get ready for it. So we're going back what? August 2017. So August 2017, GDPR was already ready, completed. Its development started the 4 or so years before. That's where you have to look. So by the time it went live and being applied and enforced, it was already at least 2 years behind. We had the chatbot craze of 2014-17. Just when GDPR was about ready, we had the racist tie and all those things. Transformer models came up in 2017. GDPR didn't know anything about it because it couldn't, right? 2013 mindset. So that's what I'm talking about. You have to look in the future to be futuristic. To do that, you have to understand the current state of affairs, the current developments, who is behind those, and what is their vision. Otherwise, you're going to have laws for the past. And we engineers, we just going to develop a solution that are just not that good for society overall. Of course, they will have benefits for sure. Long run, they will be toxic and essentially a liability.
Before going into the rest of the panelists, I would like to come back to the Ish Jain and continue on what Bogdan has. Ish, I want a small interjection from you. Like, as
Yes.
Bogdan was saying, like engineers have to understand the legal language. There has to be some kind of understanding of the domain so that better solution can be addressed. In addition to that, do you think like the financial courts, like arbitration courts as a special domain, do you think technology courts are the future to continue? Like something on the lines of technology courts where all things technology can be addressed in a speedy way?
Well, I think we do not require separate technology courts. We require separate, technology arbitration centers, because a lot of these disputes, uh, unlike other traditional disputes, you have two different sectors. One is the domestic one and one is the international one. But moment you talk about technology, it's bound to be that it transcends borders. And moment it transcends borders, it is bound to have conflicting laws. It is bound to have parties from two different sovereign nations, and each wanting the adjudication to be done by their own state, for their own preferences, and for favorable orders. It's a human tendency, and it's going to happen. It's nothing wrong, and you can't change it. So the only way to get out of all that is to go to arbitration. But the problem with arbitration is you don't have arbitrators who are skilled in technology law. They have very limited knowledge of technology. They've come from a generation where technology was not, of utmost importance. Many of them are still not familiar with concepts of, how to use an iPad, and how to use liquid text, or how to use, good notes, or how you can do basic internet functionings. So these are the things which requires more addressing rather than technology court. You can have arbitration centers which are predisposed to only technology matters. You can have it, have the headquarters in one country, and you can have arbitrators from all over the world. And depending on the kind of dispute and the kind of jurisdiction that the parties are in, you can pick your arbitrator from that particular jurisdiction, or a central jurisdiction where, both parties can meet. So those are the ways. But technology is something which is beyond. It's always going to be beyond the courts. It's not something which the courts will be able to address as efficiently as it would normally be in an arbitration, uh, because of the cross-border nature. I mean, parties are eventually going to choose arbitration as compared to court litigation because of the cross-border nature. Not to say that the courts are not equipped to deal with it, uh, but it's not something that the parties are going to select.
So let's move on with this discussion. So I have two contributors. One of them also is an editor of the first handbook. So I have Sanad and Akash. They are our colleagues at ISAIL, and we together have developed this handbook. So let's talk about the perspective of developing this handbook, the initial days of the project, and how was the experience. So I'll begin with Akash. So Akash, you tell me, how was the experience? What do you think when it comes to our vision for the handbook, and do you think that we have at least succeeded in building something? It's a different thing how the audience and how will people react to this. That's a different domain, but I just wish to know what you think about it, and then maybe Sanat can add on.
Sure, thanks, Abhivardhan. At the outset, I totally resonate with what Bogdan and Ish said, and the issues which they talked about. Uh, we have tried to cover those issues in this book, and this book attempts to address these issues. Uh, I remember our first handbook, 2020, which was released in 2020. We had amazing topics, which I think nobody else covered. Topics like convergences between technology regulations and international cultural law, for example. And in the newer version, that is 2021 version, we have topics like art and studies. We have topics like international law and political policy. Some of the other topic includes, sports law, for example. So I think these are very interesting and great topics. And this book actually is a very good anthology of different research works. And I remember while I was assisting Abhivardhan and the team with editing these books, we were astounded with the kind of research which people came up with, and the innovative solutions which they gave. And we tried our best to accumulate everything in a book. Well, I'm sure in our next version we'll see a lot of Chat GPT, GPT-4, and metaverses and related regulations in respect of these things. And I'm already excited for that. So, and I'm sure, like, I'm aware that many more exciting things are going to come up. I'm looking forward to that. Yeah. Thanks a lot.
Thank you so much. Sanad, since we are at the conclusion and we would request all the panelists to give some concluding points, what do you think when it comes to your experience of writing certain chapters, and what do you think of the project as a whole as far as what we have done in ISIL?
Well, when it comes to the project as the whole, one thing which I truly appreciated was how there was this underlying tone of having indigenous policy being developed for separate countries. Because let's the truth of technology in our times is that almost all of it is based on data, and whatever data you gather from different societies and cultures will end up providing you different insights, and whatever technology is developed bases that data would have different conflicts. So I, being a legislator in India, can't just cut, copy, paste some, let's say, your Europe's legislation and apply it to India, because there are different challenges which we as a society face in India, and the data which we gather will also reflect that. For example, let's say racial bias may not be as prevalent in India as, let's say, caste bias. So if we apply American legislation to our society, it would fail, because our society is inherently different than any other, and in fact it's inherently more diverse and more complex. So stressing on the need of an indigenous legislation, which I found to be the underlying idea behind the handbook, was really fascinating and important.
So I have a follow-up question. I have a couple of questions. The first question would be regarding the process of book itself. Like one of the challenge, I mean, what is the main challenge while going through the project? Because handbooks are boring and they are quite extensive. So what is the challenge? You have been part of editing, writing process, the whole bookmaking process. So how do you make it interesting, or can it be made interesting? Like that is the main challenging, right? Keeping the targeted audience engaged to the whole book, especially when it's 600 pages long. It's quite a massive book. And the second question would be, outside the process of book, there has been some news about making finance and tax law taxonomies to be integrated with AI programming language. Do you think it would work? Like, what do you? So, any one of you can answer, or both of you can answer. Indulge into it, please.
I can answer from the engineer's perspective.
Yes, yes, please,
Uh,
please.
Handbook are never exciting. I haven't seen any heard of any handbook that is exciting. However, they're all very useful. They're tremendous help for referencing, but you got to know what you're doing first. The handbook is not a training manual, is not it's helping you understand things, but but you already have to have a thorough understanding of the stuff. And so it's a tremendous help in as a reference. Of course, because otherwise, I mean, you can't remember all the details, and details are very important, of course. Small things make big things. You don't understand the small things, you're not going to understand the big things. And that's the reason for handbooks, I think, the primary reason. So it has to be well written, easy to read, and so back and forth. That goes for any documentation and any publication. But I mean, reading it, 100, 200, hundreds of pages, it's not going to happen. However, it has to be very well searchable. So you have to have a very good search engine, so that you can find not just keywords, but paragraph, chapters, section of the book that will be limited to potentially, half a page or maybe a few pages out of 500. That just goes there, pinpoints of narrow down the area that you're really interested in when you inquire. And then you can connect the dots. Now, ChatGPT style of models can play a role there. Yeah, this is very practical, helps a lot of people of different expertise get things done properly without spending too much time and without de-skilling them. Because you still have to know how to search. When you communicate with ChatGPT style models, it's better to present the context in a two-liner. They will make the answer much more accurate. But for that, you have to understand where you stand. What is a problem you got to solve, where you are, and things like that, right? Okay. So it's not going to de-skill you if you apply it for this kind of use cases. If you're just looking for shortcuts, you're going to end up de-skilled. That means you're not going to be competitive anywhere with your peers, in any serious discussion, looking for a job, advancing your career or you're not going to be competitive anymore. You're going to become a shortcut, and that's not good. But in this case, it will actually help you skill up faster, for sure. So that would be a good case for ChatGPT and generative AI, what is called models, to be used. Summarization. Start any thorough publication, serious publication, not newspaper articles, say a handbook, with a summary. Have a summary there. But the summary, it's a big thing, right? The summary of, say, 3 pages that really gives you the most important message that handbook is about. 3 pages compared to hundreds, or maybe 100 or so, much, much bigger, just helps you at a newbie figure it out. Should I use this handbook, or why should I use it handbook, or where? That's very important. Knowing how to read documentation is the first step in using documentation. And I would know that was the first thing I was taught when I was working with Nortel. That was more than 25 years ago. I have shelves of books about the system documentation. I'm not exaggerating, shelves, like what you have on the background, Abhivardhan, similar to that. They're all about certain things. And then I knew only the basics about how do I connect the dots. The first thing I was taught is how to read documentation. How is those shelves of books structured? Because it was structured, they have a certain sequence that was not difficult to understand, but you needed guidance. And once you pick up, if I have 25 books that are all hundreds of pages big, because technical documentation is not going to be small. Now I figure out which one I need with ease, just like that, because I know the structure, I understand what's all about. Summary, right? Summary. And then, but how do I search within those? Some books were 1,000 pages. How do I search through them? Remember, that was in the age when Google didn't exist and this like that. So you didn't really have an electronic means of search much. So where do you start? Where do you look at? So mastering that and that means you already done half of the job. That's where you have to start. Understand how to read documentation. That's a very big deal that nobody talks about. That doesn't apply if you just have a book of 50 pages. Of course not. When you have shelves of books, like, and you will end up have shelves of books because it's unavoidable, how do you do that? So, and it's not going to take a day or two. In my case, it took a few months to really understand it to the core. I think probably a good 6 months. Well, that doesn't mean I didn't use them in the same time. No, of course I did. But after about 6 months, I could say, I know exactly what to search for. I didn't even have to think, like it was a couple of seconds process, and what to search in through the books. All was taking like a minute or so. While for somebody that didn't know how to read documentation, well, they just couldn't do it. It's not like it was taking a day. They just couldn't do it. They're just going around these circles. So I think the same applies here with a legal handbook. Who is it written for? Is it just for people that are deep in the domain? I mean, Ish will gonna go there and just fly through it. Okay, he's a professional. You just need what? 15 minutes, get accustomed to the, I don't know, the handwriting and all. That's it. But for me, oh man, I will need to go to Ish and spend a day to teach me how to read it. Not what it means, but how to read it. So write it for the audience. Write it for the audience. There's going to be handbooks for engineers, legal handbooks for engineers. I think that's where it goes, and rightly so. We do need legal handbooks for engineers, but written for engineers, not for Ish, not for Akash, not for Sanat, and the heck no for Abhivarta, right? Written for us engineers, and maybe they're not going to be 600 pages. Maybe they'll only be a couple of hundred pages. Nonetheless, it will be a tremendous tool and help for us to understand. Likewise, when we develop for law firms, for maybe a justice department, we have to develop and write everything for them, because they're gonna be the one that, first of all, they are the one they pay, but then they are the main stakeholders. But at the back of them, it's the population that may end up in the dock. And so the legislator will base their decision on those handbooks in some good respect, right? So we have a duty for the people that end up in court for various reasons. I'm not saying they're accused necessarily. It's litigation, is all sorts of reasons. So those are also the stakeholders of the solutions, not just those that pay for it.
Yeah, definitely.
So I
Akash
have
and
a
Sunil.
question for Abhivardhan before we go back to Sanad and Akash for the last question.
Okay.
So Abhivardhan, as you have been actively involved in the process of the project, do you think your project stands up to all the objectives that Bogdan has highlighted at the moment? Are you confident about that?
See, I would say honestly, thank you so much for the question first. I think at least it is for those who wish to develop some understanding of law when it comes to artificial intelligence, which is why we covered so many areas like family law. I mean, imagine international family law is not such a mature field when it comes to technology. So there was an example in the chapter where we covered ODR forums for divorce issues, or let us say alimony issues. I think it was a case in Australia, right? So what we tried to do was, because I realized that Indian law professionals and law students have one great achievement when it comes to doing certain things in research, that they actually can develop and at least analyze global trends. Some of them might not be able to do Indian approaches, but at least some can try. But a lot of them, at least, who are capable professionals and students, very talented people, they actually are very good at analyzing global realities. That's where we realized that yes, it's a book for the global and Indian audience with an Indian twist. So I think in certain ways we tried to achieve the objective. Or I may remember there was a chapter we tried to include, sadly we could not do, which is international gaming law. And a very fascinating chapter it was. We were trying to cover a little bit aspects of metaverse and in gaming, but we could not find enough sources, but we tried our best. There was also one chapter which was international law and quantum computing, but I think it was way too much because again there is no proper data or source or any archive paper to look forward to. So I think in certain ways we tried to achieve, because this book is meant for lawyers, this book is meant for law students, this book is meant for people in the fraternity, and definitely for those in public policy. Because I'll just give a quick example before Sanad and Akash jump in. I had a discussion with somebody in the international relations field, and they actually told me that they had gone through a lot of technology law papers by various organizations and various people who were litigators, and they had published in various reputed law journals. They told me one thing, that there's a great gap between technology law professionals and public policy professionals in technology policy, because of the lack of simplification of addressing any legal and policy issue, which is like, for example, you have any chatbot or any AI, and you wish to decide the legal boundaries as to how it works, how you define it, its legal or juristic status. And sometimes it gets complicated because lawyers are expected to argue on issues. But it could be an issue that lawyers are not meant for governance, they're not meant for building a policy framework. And then the person said, okay, fine, I have an IIM Ahmedabad paper of 2015, which actually tells me what is India's technology framework, at least at the beginning point, from the IT Act to the Digital India Act, which is under discussion. So that's where we think that we try to simplify things. That's why I had a chapter on the Indo-Pacific, because Indo-Pacific is an area which I'm very much interested in. We think that in ADR, once the Bar Council regulation has come in on foreign lawyers, let us see. Maybe India will have more arbitration centers, especially for technology arbitration. Maybe in future. I mean, we have started with IAMC. We have started with the Lucknow center. We had the Delhi and Mumbai centers for sure. So that's where I think we have achieved some objectives, if not all. But I'm being humble here because I think that's what happened. So I'm at least happy that our team did the best, and definitely the forward by Mr. Ishjan was great, a great contribution. Especially one more forward by Mr. Gregor Strojan, who is the co-chair of the AI committee in the Council of Europe from Slovenia. Due to certain reasons, he could not join, but he sends his best regards.
So before Abhivardhan enters into the concluding part of the session, Sanad and Akash, can you go back to the question about tax and finance law, where they are trying to bring in AI programming language to address some of the challenges regarding these laws? So do you have any perspectives on those issues?
Sanad, you may go ahead.
Well, if I'm not wrong, tax and finance laws to some extent they are very mathematical in nature. So let's say if certain circumstances are fulfilled, then you're either liable or you're not liable. Uh, and when it comes to AI programming and integration of technology, a very recent change which the Indian government has brought is with respect to company compliances, where they have made all the forms machine readable, where they are using AI to essentially intimate the companies when their forms are due. Uh, so basically, what I'm trying to hint at is that when it comes to certain laws which don't really have subjectivity in their compliances, um, having them aided by AI infrastructure, it's a very welcome move.
Akash, would you like to add?
Well, yeah, I agree with what Sanat said. And so, finance and tax laws, the more scope for any field uh, being, scope of monotonousness, uh, there is going to be a technology tool, uh, which can take over the tasks. And I would like to share a very interesting comment somebody made on Twitter. He said, "It is not the AI which will replace you, it is the person who can use these AI tools more efficiently that will replace you." So, and just on a lighter note, I'll just say to Bogdan that I think all these engineers are just taking revenge for every time we threw away a manual which came with an electronic device we purchased. That now they won't read our books and they won't read up the laws. And well, let's but just to add on that, I am aware that there are many institutes made in the European Union, like the IEEE, which actually frames the code for people who code, people who make these technologies. Because let's face it, all of these things are coming from coders and technologists and engineers. And we are just trying to ensure that there is right balance in the society for all of these innovations. So I think more institutes like IEEE is an example, or is the solution for getting that balance.
Definitely. So usage of the technology is the key, right? Practice the usage um, with the aim to practice in the right way, extract maximum value from it. But that means you have to know the tool, because um, you cannot put it to good work. Or if it's malicious, defend against that tool if you don't know it. And that's why in security, the best security people are the people that also think like hackers. Because otherwise, how can you defend against something that you not really understand? Not going to happen, not effectively. So, as I will quote Dennis Rothman, one of the renowned technical authors on AI. So I'll quote him here: use AI as a tool or be the tool of AI. You already said, Akash, people not going to be replaced by the technology. They will be replaced by other people that makes effective use of the new technology. That's exactly right. And so get upskilled and start using it, but for real use cases, not for wishy-washy pies in the sky. This is just going to be a waste of time. So for real use cases, they don't have to be big, but they have to be real and useful and practical. So you definitely start small, but the key is continue. Read about it, get your hands on it as much as you can. I'm not saying give up law, don't read about famous lawsuits that happen around the world. I'm not saying at the expense of your core background. No, I'm just saying complementing that background and put it in practice to enhance your background, right? This is not a competition here. It's some symbiosis, sort of speak. So yeah, Akash is definitely right in what he says. Get on and use it, experiment with it, keep an open mind. You will have, I reckon, like I have a lot of contradictory thoughts and ideas. Like this is great, oh, this is rubbish, and then vice versa. What was rubbish now was great. What was great now is rubbish. As long as I gradually understood more and more about it. So try to keep neutral, because until you can say, well, I actually know it, then is a very dangerous path to categorize it. And we've seen with GPTism where it went to essentially a cult, like Bertology, like it's a wonder weapon or wonder this or wonder that, and humanity will benefit greatly. No, it won't. But that doesn't mean it cannot. Of course not. Of course it can. And of course it's open a lot of possibilities, but those possibilities are not inherently good or bad. It's what you make up with them. And there's no laws around it, and there's no legal framework, and there's no much regulation. I mean, yeah, GDPR and that's about data. What about the algorithms? What about the systems themselves? What about those feedback loops that close what? They start in, I don't know, in Mumbai, let's say, and they close back in London. But not just in London, maybe in Australia too. Maybe you can't know, because AI system has one of the distinct properties is capability overhang. What capability overhang is that no one, not even the most advanced engineers that developed and built and thought that system, can know what the system is capable of once it's live at scale. It's been proven. So the system develops capabilities or uncover capabilities as it's put to use in real life. Capabilities that no one in the world can know about it. Not that they could not think about it, it's just not possible to know about them. The so called unknown unknowns.
Yeah, definitely. So let's go with the concluding remarks. I think each of the speakers can take a minute and conclude. So we'll begin with Mr. Ishjan. Sir, how do you wish to give your conclusion?
Well, I think, Bivardhan, the only thing that I would want to say is best of luck for our future endeavors. You've done a marvelous job so far. And if you're coming up with the next edition, a piece of advice would be, if you're going to come up with regular editions, it is better to start basing your editions on themes. So pick your theme and then take the papers of that particular theme. So then, the people from that particular industry would, because AI is so well spread that you have industries within AI itself. So you, on one hand, you deal with family law, and on the other hand, if you deal with metadata or data protection or privacy, it's too wide a spread for you to cover that kind of an industry. And what happens is, somebody who reads the book does not get the entire picture of probably data protection or the entire picture of family law disputes. So if you're basing your theme on one particular aspect, it's more easier that this particular edition is for data protection or for XYZ or for GDPR or for whatever concept. So you have all the papers in that particular sector. So when you're talking to people, and when people have to refer to the books, they know which edition to refer to. And that'll be a better way to theme your book, because this appears from the conversation that I've heard to be going to be a regular affair for you. So if that's the case, then you rather base it out of on the themes. And if you're getting more proficient and efficient at it, probably you can do three editions together. You have one edition for data protection, which has about you know 12 or 15 chapters, and one for something else, which has about probably just 8 chapters. May not be the same width of the book, but the idea is to cover all the topics in relation to that sector. For example, you're dealing with metadata, so have about you may not have a lot of legal disputes or legal regulations around that concept, or a lot of papers people being able to write on that concept. But about 7 or 8 also allows you to make a good volume. And I'm sure you can use this as one edition and the other as a second edition and launch both of them together. I'm sure it'll be a better market, and a better way to deal with what Bogdan also had in his mind. You can have different in that same book, you can have different sectors, one from the legal perspective and one from the engineer's perspective. If you have one theme, so it acts like a bridge between both sides, and it'll be better. People who are like, for the lawyers, they would want to read the whole aspect from an engineer's point of view. Because a lot of time when I act as an arbitrator, I want to understand from when this contract was entered into, what was running in the engineer's mind that he had to agree to this clause. Because that boils down to the fact as to what was the intent of the parties at that time. And it becomes very relevant for us to read, rather than just listen to the arguments made by the lawyers that, yeah, this is what the engineers thought. But if some engineer has written some context about it, it becomes more easier for us to understand their perspective from that angle. So I think, yeah, that's my 2 cents on the advice that I have
Yeah,
for your next edition.
I really appreciate that, and I think you have kind of given us an idea how to take this handbook project forward. Maybe, so maybe I think let us see how things go, and if we would be in a position, maybe we will come up with something like on AI and IP law specific issues, maybe on AI and data law specific issues. So I think now with that we have generalized too much. Now that we can become more specific, and I think
Absolutely.
that's how we can take it forward. Yeah, um,
Absolutely.
definitely. Bogdan, 30 to 60 seconds, please. Conclusion. Yeah.
Um, teach yourself about tech, and the engineers teach yourself about law. That's it. Am I within the 30 seconds?
Okay. Akash, Sanad, what do you think? Concluding remarks.
Well, in conclusion, I'll just invite everybody on the panel. Uh, Aditya, Bogdanish, Sanad, everybody had amazing ideas. So let's just come together and for the next handbook, let's just contribute something phenomenal.
Thank you so much, Sanad.
Well, working on the handbook and exploring a diverse set of issues with respect to AI had its own charm to it. But as Mr. Jan suggested, that maybe we should try and act upon specific issues, and instead of exploring the width, explore the depth. So I guess I'm looking forward into deep diving into specific legal issues, starting the next edition of a handbook.
Thank you so much, Sanad. I think it was a pleasure to have all the panelists. Thank you so much, Aditya, for hosting this. I think we will be concluding this session. Thank you so much. It was such a
Thank you,
pleasure. And
Abhivardhan, for indulging me. So it was my pleasure.